heard, but I was just talking to Vice Chancellor Leeds about what she would like me to call her, because not only is she the Dean of the Law School and the new Vice Chancellor and Professor of Law, she also used to teach here at KU before going to the University of Arkansas. So, and along with all of these impressive academic endeavors, Professor Vice Chancellor Leeds also has a strong record of public service, which includes appointments as a justice on the Cherokee Nation Supreme Court. Today, she'll be discussing the impact of the opioid epidemic on tribal nations. Please help me welcome Vice Chancellor Leeds back to Lawrence.
Well, thank you, Erica, for that introduction, and I just wanted to thank you for how well run this symposium is. I think over the years, many of us have participated in these, and just the execution of this one was flawless. So thank you, and I look forward to working with your other editorial staff as we convert these into papers. So it is a bit of an old home. We have a lot of former professors from KU coming back, and I was chuckling to myself about this particular classroom because the last time I taught in this classroom, it looked exactly like that, but I didn't. I taught Property 2, which is not a class on the curriculum anymore, and I taught in the spring semester where I was 7 to 9 months pregnant. And so today has been much more of a pleasurable experience than the last time that I was in this particular classroom. As the day goes on, it becomes more and more of a tall order for the speakers to contribute something new that hasn't already been touched on today. And so what I hope to add to this discussion is the perspective that comes from the tribal governments and from the tribal communities that are impacted by these issues. And I hope to talk about some of the strategies that were employed many years ago before it got to the stage of litigation by the tribe, trying to combat that in their own system. And then also talk about kind of the ongoing litigation that are before us today. By my last count, there are 22 different tribal governments who have filed in some court similar claims that we've heard about that the states and local municipalities have brought. But the nuance is very unique because the tribe fits into some of those categories, but also takes on a lot of the direct health care delivery in those communities. And so as we start to quantify hypothetical costs that governments and local municipalities allege in these lawsuits, I think tribes are uniquely suited to be the only entities that with specificity can talk about exact health care costs around some of these issues. One of the things I was going to share with you is that, based on the federal data that's available through Health and Human Services, although this epidemic is dreadful in many places across the country, it's even more pronounced in what we call Indian country. And this graph, I know it's difficult to see this far away, but the top two lines, the dotted line and the blue line, are opioid deaths as associated in the opioid deaths in the Native American and Alaska Native community as compared to the death rate of all races combined in the United States, which is the line that's black on the lower level. And if you look at the years, at about 2003 to 2005 is where it really spikes. And that represents what we're seeing in the Indian communities of there has always been the case over many decades that drug abuse in general has been higher in Indian country, but we have seen that the opioid crisis has far taken over meth in our community, and that once the pills are eliminated and people can't get access to them, then our rate of heroin abuse is now skyrocketing. And that now that's a bigger issue in our communities than meth. And when I say our communities, I'm talking about the tribal communities in Oklahoma, which I'm going to spend a little bit more time on, but it's impacting different places in different ways. So if we start from the premise that the Native communities are the hardest hit, of the opioid crisis. But then you think about the size of some of these communities, it's really alarming what's going on. Now, I'm going to talk about the multiple Cherokee Nation litigations, which is the largest tribe in America. But when you look at some of the native populations that are impacted by this and the rates of death, it's rising to the level of community survival in some of these areas. And so, for instance, one of the most recent tribes that issued their own tribal government declaration of an emergency in this area is the Wampanoag tribe that is on the East Coast. And they have a total population in their community of 2,900 people. They made their declaration in March of 2016. From January 1 to March 15th in 2016, out of a population of 2,900 people, they had 11 opioid deaths just in the age group between 25 and 35, right? So very pronounced for incredibly small communities in some sense. Now, my last slide is just to give you a graphic of the area of Oklahoma that the Cherokee Nation has tribal jurisdiction over, and then I'm going to start talking about those lawsuits filed by the tribe first. So Cherokee Nation of Oklahoma is 14 counties in the northeast corner of Oklahoma, bordering Kansas, and the overall tribal population for Cherokee Nation is just over 360,000 tribal citizens located throughout the globe. So if you compare that to like Wyoming, it's very close to some of the populations of states. But if you're talking about the people who are Cherokee citizens that reside within the Cherokee territory here, we're talking about 175,000 tribal citizens that reside in this area. And the lawsuits that were brought by Cherokee Nation are talking about that subset because they're the ones that are most likely using Cherokee health facilities and are employees of the tribe in addition to being tribal citizens. So a lot of different hats that the tribe is wearing. The tribe has the same arguments that the municipalities have just in terms of local governance structure. But Cherokee Nation in particular is the gold standard throughout Indian country for an integrated healthcare system. And so the tribe operates its own hospital and 8 different clinics throughout this jurisdiction that's on the slide. Behavioral health programs, cancer programs, emergency response, anything that you could imagine in an integrated healthcare system, the tribe is the one that's the deliverer of those services managing their own hospitals. Now there's a federal component in this as well because based on a lot of treaty language and also federal trust responsibilities to the tribes, just like there's a Veterans Administration federal healthcare system, there's the Indian Health Service federal system. But for years now, the tribes that have had capacity have exercised federal statutory authority to compact with the IHS to where the tribes are the ones that are running these hospitals. They'll receive whatever allocation of federal money that IHS would have put into their jurisdiction, but they take it over knowing that they can do it better in their own communities. And then those tribes that have been lucky enough to have any success in economic development, particularly if it's gaming, there are additional funds where the tribe has skin in this game, where they're putting additional money into their healthcare system, and some of that is mandated by federal law because the regulations that apply to tribes that have casinos, they can only spend their money certain ways, and there are buckets that those can go into, and healthcare is the largest bucket of expenditure nationwide from Indian gaming. In the Cherokee Nation, the tribe I mentioned has 175,000 people who live in this jurisdiction. They also employ over 14,000 people. And of those 14,000 people that either work for the government side of the tribe or the businesses side of the tribe, it's 58% of every employee for the Cherokee Nation works for Cherokee Nation Health, right? So it's a big operation. The tribe started to notice about 10 years ago that things were spiraling out of control with the opioid addiction in the community. And so over a number of years, they self-regulated to make sure that their health systems were not making part of the problem, more pronounced. And so some of the steps that they took in advance of litigation is they were looking at the amount of money that was actually being spent in their facilities toward recovery programs, and the biggest item ticket in the budget was a number of these babies that are being born addicted and how much expenditures were going into the system. Oftentimes it bled into more of what we call contract health. So Cherokee Nation's hospital is not the best hospital in the state of Oklahoma. There's 3 other hospitals in Tulsa that are much more capable of handling particularly special needs issues. And so a lot of costs of, like, every time one of these babies is born, to life flight it to one of the special units of one of these hospitals. And then the Cherokee Nation pays money to contract out to the hospitals to pay for those services for the people that come underneath their healthcare system. So they were looking at that, and if you look at the other health crises in Indian country, namely diabetes and heart disease, all of this money that was spent on addiction issues then doesn't get spent addressing the wellness issues on the front side of the oven. The other thing that became very pronounced quickly was anecdotally the social workers were seeing an uptick in how many of their cases had opioid touches in the case. So it might not have been the case that the child was removed from their home in the first instance because of an addiction issue, but somewhere along that case file, maybe in that first foster care placement or an extended family placement, there would be opioid addiction issues in that case file. And in preparation for the litigation, because the forms and the intakes several years ago didn't have a place for you to quantify the data that this was an opioid case, in preparation for the litigation, they went back and hired a third party to go in and audit all of the social welfare files over a 10-year window. And what they found was staggering, right? That of every open case in the last 10 years in the Cherokee Nation, 41% of every case had some opioid addiction issue in the case. Now, those are the cases that come up in the Cherokee Nation's own system. But if you look at that jurisdiction, there's 14 counties of the state of Oklahoma, and they all have state courthouses, and they all take jurisdiction sometimes as well. And so when you look at the foster care placements that come out of state courts in Oklahoma, 70% of those cases where there's a Cherokee child placed in foster care, 70% of the time they're placed in a non-Indian home. And then sometimes it leads to adoption placements outside of the tribe. And so what our social workers were describing is that you've got 30 or 40 years of federal protection under the Indian Child Welfare Act to keep Indian families intact. But now, because of all these addiction issues, it's cutting against a lot of those strides that were made because there's this many more kids placed in foster care. So that was some of the issues. And then in looking at the diversion issue, right, that the theory in all of these cases is that the manufacturers and the distributors know that they're flooding the market with extra pills that must be diverted elsewhere. We know from the Cherokee Nation's research in this that in 2015 and 2016, there were 184 million pills just in this 14-county Cherokee Nation district. And so it's even more pronounced than the statistics discussed this morning. People who could be reasonably using these pills under a lawful prescription versus the number of pills that are in the market. But what the Cherokee Nation started to take a look at is what they could do in their own healthcare delivery system to address these issues. So Cherokee Nation was a very earlier adopter of using IT to address monitoring systems. So before there was a PMP, Cherokee Nation had their own prescription monitoring service before it was required everywhere else. Now Oklahoma is one of the few states that has real-time access in the PMPs, and that's largely because the tribes were really trying to be proactive in this issue, and the state worked with them to do that. What the Cherokee Nation also did 6 years ago is that they modified their own drug formulary as to what drugs would be dispensed by the pharmacies in their own clinics and hospitals, and severely limited the type of drugs that would be prescribed, the numbers, and for what circumstances, right? So a lot of internal controls. They banned the visits of drug reps to those facilities to visit the doctors. So they addressed that issue of it. And then they were one of the early adopters of not doing paper scripts at all. And so how the pills came into the Cherokee Nation clinics is interesting because it gets to the jurisdictional issues in this case. So you've got 570 different tribes across the country. There's no way that each one of those tribes is going to have a contract and do price negotiation themselves. So what they do is they piggyback Indian Health Service onto the VA contract. And the Veterans Administration makes a big contract with each of these distributors and manufacturers about what the pills are going to cost. So if the Cherokee Nation Clinic has an order and they put that in through this federal process, it goes to the distributor, but the distributors are the ones that are actually delivering it directly to the Cherokee Nation's clinics. Okay? That'll be important in a minute when I talk about consensual relationships test for tribal court jurisdiction. What was early realized, though, is that if the Cherokee Nation has shrunk so much the distribution in their own clinics, how do we address the doctor shopping issue of leaving Cherokee Nation Integrated Health and going somewhere else for a prescription? And then how do you track and understand what's going out through third-party pharmacies, like your regular retail pharmacies, versus the pharmacies that are there on Cherokee Nation? Now, I mentioned the employment magnitude. Cherokee Nation, they are not self-insured in a private contractual sense. All the Cherokee Nation employees, which they are the largest employer in the 14 counties besides the state of Oklahoma, because you've got all those offices, so the governments are the two largest employers. But Cherokee Nation has Blue Cross Blue Shield, right? And so if you want to pick your own doctor and go somewhere else, then you go to CVS or Walgreens, and that process, though, would be reported through, the insurance that would come back for the tribe's reports. Now, I'm going to speed through some of the harms because the legal theory of the cases that were brought by the tribes are almost mirror those that we've already talked about in the state or federal courts. The only difference is that we are talking about a very, very close nexus to the direct cost in terms of calculating your damages, because the tribe is expending this themselves rather than people going to third parties. So the Cherokee Nation brings the very first of the tribal litigations, and they filed the lawsuit in Cherokee Nation Trial Court, which we call the district court, and that happened back in April of 2017. And the defendants in that case are two categories of defendants. It's the category of the distributors, which were Cardinal Health, AmerisourceBergen, and McKesson. And those three account for 90% of all of the pills that are brought into Cherokee Nation. And then there are 3 retail pharmacies that were sued, and it was the big 3, CVS, Walgreens, and Walmart. The tribe decided not to try to sue the manufacturers in the tribal court because they thought that it was a further reach in terms of their ability to have recognized jurisdiction over the manufacturers. And you might scratch your head on that, right? Because our regular discussion of products liability in a court of general jurisdiction in the state is that you follow that up the chain of commerce, and of course you have jurisdiction over all of the people involved in putting this into the stream of commerce, right? Well, in the tribal court jurisdiction cases, tribal court judges, in a real sense, feel like magistrate federal judges. Because when they have a case before them and there's a challenge to jurisdiction, they will determine their jurisdiction first, but the very next thing that will happen is that there will be a federal lawsuit that gets filed, and it will be a non-citizen or a non-Indian defendant going to federal court and making the argument, under federal law, that tribe doesn't have a government power over me. So injunctive relief from the federal court to keep the tribe from hearing this case. And it happens so frequently that, like I said, a lot of tribes in their civil procedure codes, they'll provide for stays or for interlocutory appeals to let people go ahead and exhaust these jurisdictional claims through the tribal court up to the federal court on that narrow issue of whether the tribe has jurisdiction. And if they do, then we'll come back down and we'll have a trial on the merits. But those first cases in the tribal court are always making the case in the tribal court that that's a proper venue with subject matter and personal jurisdiction over the parties. Now, in state courts, you can get to minimum contacts pretty quickly on the commerce and the interaction question, right? For the tribal courts, the way that it has happened over the last 30 or 40 years in federal jurisdiction is that federal courts have a very narrow view of when a tribe is exercising proper jurisdiction. And these cases start in 1979 with a case called Oliphant versus the Squamish tribe. And in that case, the United States Supreme Court said categorically, Indian tribes will never have jurisdiction over a non-Indian defendant in a criminal case, right? And it has a lot of undertones of we're not sure that due process is there, we're not sure that they're as unbiased as our courts, and so there's some skepticism by the federal court about whether that tribe should have the authority to hear this case. And it rallies around, has that defendant done something to purposely avail themselves to where they would expect to be brought into a tribal court, right? And so those kinds of concerns are there. So in Oliphant, there's the categorical bar. Anytime it's criminal jurisdiction, no tribal court jurisdiction. 2 years after Oliphant, the question comes up about regulatory jurisdiction and adjudicatory jurisdiction on the civil side. Are we going to have that same sort of categorical bar where we would never let a tribe have recognized jurisdiction there? Or might there be some times where we're comfortable with that? And so a test that evolved in the federal courts is that, yes, there's 2 times that we might be comfortable with it, right? And this is the 1981 Montana versus United States case. One of the times that we're going to be okay with it is if there's a direct contractual relationship, right? You've entered into some deal with the tribe, and it's very foreseeable that you would have that claim brought in tribal court, okay? So it's more than a minimum contact, but there's a contract, there's a stream of commerce, etc. So on the consensual relationship piece here, the tribe said it might be a stretch on the manufacturers because they've never set foot on our reservation, they don't have any direct contact, they might not know that their drugs are going into the Cherokee Nation. At least that's a better argument, right? But with the distributors, not only do they get an invoice from the VA that lists out the Cherokee Nation with all the other tribes, and you know how many pills were delivered, and the payment system goes through that way, but the actual cars are making the delivery, right? So there's no way that there's not a consensual relationship is the tribe's argument here. The argument as to Walgreens, CVS, and what Walgreens, Walmart, and CVS, a little bit more difficult to make, right? They're not coming onto tribal land and the tribal facilities. What they're doing is they're filling these scripts, right? And so the argument is you haven't exercised proper care in your stores and diversion is taking place, and it's because you're not abiding by these general, federal standards. All right, so that's the consensual relationship piece. The second time that federal courts are okay, at least in theory, with tribes hearing cases where a non-Indian is the defendant, even if there's not a direct contractual relationship, is this Montana 2 test, which says there might be times where the conduct of the defendant either threatens or has a direct effect on the political integrity, the economic welfare, the health and safety of the tribe, that we would feel okay with the tribe having jurisdiction, right? The problem is that once the federal courts have pronounced that possibility of tribal court jurisdiction, there has never been one case in the federal system at the circuit level or above where the federal courts have said, yes, based on this direct threat to health and safety of the tribe. So to the tribes, this feels like a goalpost possibility that's hypothetically there, but you can't quite reach it. And that's what happened in the federal case. So it goes to the tribe stays the litigation so that there can be the federal court inquiry into jurisdiction. And one of the things that's part of the narrow review in the federal courts is that there's a pretty well-established doctrine of exhaustion, right? That if there is a reasonable, colorable claim for jurisdiction over this case, we will go ahead and send it back down and let the record be developed there, and then we would hear it at the end of the day. The federal court case in North District of Oklahoma, in this case, they said no jurisdiction because there's not enough of a consensual relationship here, right? They were very bothered that it was with the VA and that it wasn't this direct contract between the tribe and the distributors. And on the health and welfare issue, that's a hypothetical mass tort, but we're not convinced that it's so serious that it implicates, tribal sovereignty, your right to govern yourself, and et cetera. And so what this does for all the rest of the tribes is that it wasn't just a negative ruling toward the Cherokee Nation on the jurisdictional question. It's that the federal court would not even hold the case up and exhaust tribal remedies because there was no colorable claim. There's no chance that a tribe in this context is going to have the jurisdiction or not. So to date, the Cherokee Nation is the only tribe who has tried to do this through tribal court. Everybody else has filed in state or federal court after the initial Cherokee Nation filing. Now, the Cherokee Nation's interest in this is not just that they wanted a pronouncement that their own tribal court should be the one to hear this case. They filed this before the state of Oklahoma and before the municipalities got involved. And their issue was that they wanted this resolved quickly to see if there was some way to move the needle in those communities. And so immediately after the federal court rejected the tribal jurisdiction, the next week the tribe filed 2 separate lawsuits in a county within those 14 counties in state court. That was the next step. And the 2 different lawsuits was, the first lawsuit absolutely mirrored the tribal court lawsuit in terms of the defendants involved and all of the claims. You brought in a few state law claims in addition to the tribal and the federal claims statutorily, but it was the same basic common law tort claims in the state court. The second state court filing in that same Sequoia County District Court, that is the case where they bring the manufacturers in. So that's why you have 2 competing lawsuits. Now, you would presume that because the tribe can't hear this case, that there would be such a thing as default jurisdiction to the state, that they would be the local court to hear this case. But in federal Indian law, that's not necessarily so, right? Because if you're the drug distributors in this case, and you're brought into state court, what is your first argument against state jurisdiction? This is brought on behalf of the tribe for tribal harm that was done on tribal trust land, right? So what would be the basis of state jurisdiction here? And it's not just general jurisdiction, right? Because we've had other circumstances in federal Indian law where the federal courts would not let a state court hear the case, would not let the tribe hear the case, and so there really is the situation where you could have no local court that is empowered to have jurisdiction to hear the case. The other interesting piece of this in the distributor's case is that they decided rather than challenging on that grounds in the state court, they immediately asked for this case to be removed to federal court. And the novel removal statute that was relied on is a federal officer removal provision. And the drug distributors said, we're not the drug distributors. We're carrying out this contract on behalf of the Veterans Administration Hospital, so we're acting under color of federal law, so you're in effect suing a federal officer, and you're back into federal court again, right? And the Cherokee Nation says, that was our whole point. It's a contract that you're carrying out, right? But that wasn't enough to get the consensual relationship piece. So before I move on to the other cases, it's very confusing just in Cherokee Nation because what we do have is a categorical bar on this particular mass tort in tribal court, right? And we have the one remaining state court suit because the manufacturer's piece has not been removed to federal court. It still lives in the state district court. And then you have the removed case that's now in the Eastern District in Oklahoma that proceeds against the original 6 defendants that were originally brought in tribal court. Now enter the other tribes. They chose, for the most part, to go with federal filings, a few state court filings. But in the Nebraska litigation that was brought by the Ponca tribe of Nebraska in Nebraska District Court, that was the first tribal case that was removed and consolidated into the MDL. When it got to the MDL, the tribe said, wait, we got completely cut out of the tobacco deal, so let's do something different and get together on this. So the tribes have asked the judge in the MDL for a separate track that deals with tribes and their unique situation, and not just lump them in with the states, making the argument about the direct health care delivery. And two of the tribes that are involved are relatively small tribes with 5,000 or less tribal members. And both of them, in addition to being healthcare deliverers and municipalities, they have a health insurance plan for every tribal citizen, right? And so that's one more mix in this. Now, the three largest tribes in the United States, Cherokee Nation, Navajo Nation, and Muskogee Creek Nation, want nothing to do with the MDL, right? And they want to continue their cases either in state or federal court and not be part of this discussion. So you have a lot of tension between the tribal advocates across the country as to what the best solution for tribes will be. But the overwhelming majority, particularly the smaller tribes, are pushing for this separate track in the MDL, which the judge has agreed in principle, and those conversations are moving forward at this point. As we're getting closer on time, I'll end with the two, I guess, takeaways that I'm continuing to build out for the paper. And the first one is that it certainly is the case that with all of the flurry of activity that there is not going to be a situation where a tribal court and a tribal community is going to be recognized as being the arbiter in any of these cases. And so I actually side with the smaller tribes with the opinion that the best track is to try to get involved early and often in the MDL and see if there can be at least tribal participation this time, particularly in light of how the exclusion of tribes happened in the master tobacco litigation. My second takeaway, though, is how the opioid crisis, I think, opens up a new lens into the basic question of tribal court jurisdiction, and in what instances, if ever, there will be civil, regulatory, and adjudicatory jurisdiction over future mass torts. The opioid thing is bygones because it's too far down the road, but I think that all the parties inside of Indian country at this time are desperate for some sort of predictability when it comes to civil litigations that involve tribal courts. And part of it has been, like I described, that the tribal advocates feel the federal courts have been very disingenuous in putting out this test that no one seems to be able to meet, right? But very fearful that there would be a categorical bar like there is in the criminal arena, and that makes it almost unmanageable to exercise your authority as well. There have been two instances where Congress has come in and passed legislation that creates a fix for the problems created by the federal decisions in tribal jurisdiction. The first time that happened is what I described, where all of the federal cases stacked up a situation where the tribe didn't have jurisdiction, the states didn't have any jurisdiction, and it wasn't a matter of federal law. And that was in a case called Duro versus Reyna, and it was a criminal law case. And the outcome of several federal litigations was that no local court could hear lower-level criminal misdemeanor cases where somebody was racially Indian, but they were not a citizen of the tribe that was prosecuting them. And so Congress came in with that Duro fix, and they said, in this limited instance, we are going to re-recognize the tribe's authority to prosecute these kinds of cases. So it sort of expanded what the federal courts said couldn't occur. The second time that it happened was wrapped up in the latest Violence Against Women Act provisions. And after that categorical bar, the tribes can't have criminal jurisdiction over non-Indians, there was a clear problem with local crimes happening in interracial marriages and relationships where the non-Indian offender would never be brought to justice because the tribe didn't have any jurisdiction because he was non-Indian in most of the violence against women cases, but the state also lacked jurisdiction because it occurred on Indian lands. And the only hope for there to be any justice brought in that case would be for a U.S. attorney to get involved in a pretty low-level case, which just never happened. And so in the Reauthorization of Violence Against Women Act last time, there was a very narrow provision that was put in that said, we will recognize a tribe's ability to have jurisdiction over this limited type of cases, and they would be violation of protection orders, and that the remedy wouldn't just be civil, but you could have criminal jurisdiction for a Violence Against Women Act covered protective order, so long as your tribe's courts were law-trained judges and you had certain provisions for due process in there. Right, so we have two examples where Congress stepped in and said, we are comfortable in this arena. What I would advocate for, and what I'm going to build out in the paper, is a third time where Congress steps in with these fixes, right? And it would be around these mass tort type claims where there's such significant damage that health and safety and all of these things are impacted to such a degree that they must have local jurisdiction like every other sovereign does. And so one of the ways that I was trying to think through that is, how would we know? Would there be, some parameters for the types of cases, or would there be some sort of a certification process like there is in environmental law? And so I looked to federal statutes where, over time, Congress has come in and they have said, for this particular instance, we're going to treat a tribe just as if they were a state. So there's several environmental statutes that do that, but then most recently, around these declarations of emergency, the Stafford Act was amended, where a tribe could be the one to directly declare an emergency in their jurisdiction, and then HHS Secretary has the delegation of then releasing these federal resources to that jurisdiction. That's relatively new because up until just a few years ago, the only way the tribe could have access to any of those resources was if they could politically convince the governor in their state to raise that on their behalf, or if they could be successful in going directly to the president and having that declaration of emergency issued for that community. Stafford Act has now been amended where the tribe can have that declaration of their own and then have access to these resources. And so I'm thinking about some sort of a process similar in a statutory sense where there's the capacity or capability of bringing these mass tort claims in tribal court. But I think at this point, that will only happen if Congress does like they did in these two areas and move forward. With that, I will end and we'll take questions after the last presenter, I guess, together. Will that work? Okay.